Under the Corporations Act 2001, there are several transactions that may be considered voidable in circumstances where a company is placed into liquidation. The common types of voidable transactions are uncommercial transactions, unfair preferences, unfair loans, creditor defeating dispositions, and unreasonable director-related transactions. Two of the voidable transactions that creditors should be primarily concerned about are unfair preferences and unfair loans. Unfair preferences are the most common type of voidable transaction and occurs where a creditor has received an advantage over other creditors by receiving payment for their outstanding liabilities and does so in circumstances where they knew or ought to have known that the company was trading whilst insolvent. An unfair preference is a transaction that is made in the 6 months prior to an external administrator being appointed or a winding-up application being filled with a court. This is known as the relation back period. Unfair loans. A loan is an unfair loan if the interest on the loan or charges in relation to the loan were extortionate when the loan was made, or has since become extortionate because of a variation to the loan. In determining whether a loan, the interest or the charge was extortionate, the court will generally consider the factors such as the risk assumed by the lender, the value of any security, the term of the loan, the schedule for payments of interest, charges, and repayment of the principal, and any other relevant matter. As a creditor, it is important to understand the concept of voidable transactions and how they can impact your debt collection efforts. These types of voidable transactions can be set aside by a liquidator or a court if they meet certain criteria out of the Corporations Act 2001. This means that as a creditor, you may have to return money or assets that you received from a debtor, even if you believed that the transaction was valid. So, what should creditors be aware of when it comes to voidable transactions? Well, creditors need to understand that there are several types of voidable transactions under Australian law. These include transactions that were made with the intention to defraud creditors, transactions that were made while the debtor company was insolvent, and transactions that gave one creditor an unfair advantage over others. If you're a creditor and you suspect that a transaction may be voidable, it is important to seek legal advice as soon as possible. If a liquidator is appointed to wind up a debtor's business, they will review all transactions during the relation back period that were made in the lead up to the liquidation to determine whether any of them are voidable. If the liquidator determines that a transaction is voidable, they may require the creditor to return any money or assets that were received. It is important for creditors to work closely with their solicitors to ensure that they are aware of any potential risks associated with voidable transactions and that they take appropriate steps to protect their interests. The main defense to a voidable transaction is that you received the transaction in good faith. This means that there was valuable consideration, you acted in good faith, and you did not know or could not reasonably have known that the business was insolvent. In summary, voidable transactions can have serious implications for creditors in Australia. By understanding the types of transactions that can be set aside and seeking legal advice when necessary, creditors can help to protect their interests and maximize their chances of recovering debts owed to them. Here at Cathro and Partners, our team of qualified insolvency practitioners can help you with friendly and expert advice regarding the issues surrounding voidable transactions. We encourage you to contact any of our principals at admin@cathropartners.com.au.